Dear students, today I am going to discuss with you the second part of essentials of valid Muslim marriage. In my last video, I had discussed the first three essentials of valid Muslim marriage. And they were, the first one was that the parties to the marriage must be competent. The second one was that the consent of the parties or their guardians must be free. The third one was that the required formalities are duly completed. Today I am going to discuss with you the prohibitions. That is the fourth essential requirement, that there must not be any prohibition or impediment in contracting the marriage. This means there should be absence of prohibition. The marriage should not have been prohibited under Muslim law. If the marriage is not prohibited, the marriage is possible. Now, what are those prohibitions under Muslim law? The fourth condition that we are discussing is the absence of prohibition. So the immediate question that arises is, what are those prohibitions? Prohibitions under Muslim law on Muslim marriage are of two kinds. The first category of prohibitions is absolute. That means the prohibitions are absolute. The first category of prohibitions are absolute prohibitions, meaning thereby they must be complied with. Because if they are not complied with, the consequence is going to be serious. The second category of prohibitions is relative prohibitions. Relative prohibitions are not as strict as we witness in case of absolute prohibitions. What is the consequence of relative prohibition? We will come to know as we move ahead. Now let us first of all try to understand what are absolute prohibitions and on what basis these absolute prohibitions have been prescribed under Muslim law. But before going into that, let me tell you, a marriage contracted in violation of any of the absolute prohibitions is null and void under all schools of Muslim law. All schools of Muslim law. If any marriage is contracted in violation of absolute prohibitions, the marriage will be null and void under all schools of Muslim law. But who are those people who are prohibited absolutely for the purpose of marriage? Two persons are said to be within prohibited relationship. Here we mean absolute prohibition. They are said to be within prohibited relationship if they are related to each other by, number one, consanguinity, that is by blood. Number two, by affinity, that means by marriage. And number third, fosterage, that means by milk. So there are certain relations under Muslim law which are prohibited absolutely for the purpose of marriage, and they are based on consanguinity, that is blood, affinity, that is marriage, and fosterage, that is milk. Let us try to understand one by one. Consanguinity. What are those relations which are prohibited on the basis of relation by blood? There are three categories of persons who fall within this category, that is, they fall within the category of consanguinity, and those relations are prohibited absolutely for the purpose of marriage. Who are they? Number one, a Muslim cannot marry with any of his or her ascendant or descendant, how high soever and how low soever. Ascendant means one cannot marry one's father, mother, grandfather, grandmother, how high soever. Similarly, one cannot marry one's descendants. That means one cannot marry with one's sons, daughters, grandsons, granddaughters, how low soever. You will have to think over it, and in order to understand it completely, you must go through your books on these points. The points which I am discussing today are a bit technical and difficult. So you need the help of the literature which is available in your book. Therefore, when you study from my video and slide, you must also read your books simultaneously. Or if not simultaneously, then after watching my video, you must go through your books also. Then you will be able to comprehend completely. So this is the first category of the relations which are prohibited absolutely for the purpose of marriage on the basis of blood. The second category of relations which are prohibited on the basis of blood, that is consanguinity, are: one cannot marry the descendants of one's father and mother, how low soever. How low soever. One cannot marry one's father or mother's descendants. The descendants of one's father and mother are prohibited for the purpose of marriage. Who are these people? I have given the example in this slide, and they are brothers, sisters, descendants of brothers and descendants of sisters. Remember, brothers and sisters are of three types, and all of them fall in this category. A brother or sister can be full brother or sister. A brother or sister can be consanguine. A brother or sister can be uterine. I have explained these terms when I was teaching you Hindu law, if you remember my lectures. Full blood means real brothers and sisters. Consanguine brothers and sisters are those where the father is common but mothers are different. Uterine brothers and sisters are those where the mother is common but fathers are different. So these are the relations which are prohibited in the second head of the relations which fall within the category of relation by blood, that is consanguinity. The third category under the consanguinity which is prohibited for the sake of marriage is those of brothers or sisters of one's ascendants, how high soever. One cannot marry the brothers or sisters of one's own ascendants, how high soever. Who are these people? I have given 4 examples in this slide. Father's brother and sister. Father's brothers and sister. The second is mother's brother and sister. And third is grandfather's brothers and sister. And fourth is grandmother's brothers and sisters. Now let us try to understand the first two. Who are they? Father's brother is what we generally call chacha. Father's sister, whom we generally call bua. Mother's brother, we call him mama. And mother's sister, we call him nosi. So these are the relations which fall in this category. So far we discussed those relations which are prohibited for the purpose of marriage and which are the relations by blood, relation by consanguinity. Now let us try to understand those relations which are prohibited on the basis of marriage. These are the relations which are called relation by affinity, or in other words, they are called relation by marriage. Who are these people? There are two categories of people who are prohibited under relation by marriage or affinity for the sake of marriage. The first is ascendant or descendant of one's wife or husband, how high soever, how low soever. One cannot marry the ascendant or descendant of one's own wife or husband. This is the first one. I repeat, one cannot marry the ascendant or descendant of one's wife or husband, how high soever or how low soever. Who are these people? Now, I have given the example. A man is prohibited to marry his wife's ascendants and descendants. A man cannot marry his own wife's ascendants and descendants. Similarly, a woman is prohibited to marry her husband's ascendants or descendants. For as far as the clarity and examples are concerned, you will find those examples in your book. That is why I am saying that you must read the books after watching my video. After looking at the slides and listening to me, you must read the books also, so that you may be able to comprehend it completely. There is one exception, and this exception says that a man can marry the descendant of his wife. The descendant of his wife, if his own marriage with the wife has not been consummated. I have already explained the meaning of the term consummation when I was teaching you Hindu law. I am not going to repeat it. If the marriage with one's own wife was not consummated and the marriage with that wife got dissolved, then the man can marry the descendants of such wife. This is only one exception under Muslim law. Now, the second category under the relation by affinity is one cannot marry the wife or husband of one's own ascendant or descendant. One is prohibited to marry the wife or husband of one's own ascendant or descendant. I am giving you an example. A man cannot marry the woman who was the wife of his father or his son. The wife of father here does not mean mother, because mother is already prohibited under the category of ascendants, under the category of relation by blood. Here, the wife of father is the stepmother. Even she is prohibited under Muslim law in this category. So, a man is prohibited to marry the wife of his ascendant and descendant. Similarly, a woman cannot marry the husband of her ascendant or descendant. She is prohibited to marry. For the sake of examples, you should consult your book. Now, the third and the last category under the absolute prohibition is called fosterage. Fosterage is also known as relation by milk. Now, in order to understand this peculiar relationship, let me explain. What happens when a child under the age of 2 years has sucked the milk of any woman other than his own natural mother? That woman is called the foster mother of that child. This woman has only fed the child, nursed the child. She has only allowed the child to suck her milk. She has not given birth to that child. This lady, this woman, is treated to be foster mother of that child. In old days, it used to happen. Such practice was there. But in modern society, we do not see such a situation because of the advancement in the technology and so many other things. Such a relationship is hardly found now. But their possibility cannot be ruled out. There can still be a possibility of such a situation. But in old days, such examples were there in large number. So a woman who has allowed a child who was under the age of 2 years to suck her milk, and that woman is not the natural mother of that child. That woman is known as the foster mother of the child. This is a special relationship. Under Muslim law, this is considered to be equal to giving birth. And therefore, on the basis of fosterage also, certain relations are prohibited. for the sake of marriage. Now, what are those prohibitions? A man is prohibited to marry his foster mother and foster mother's daughter. A man is prohibited to marry his foster mother and foster mother's daughter, because foster mother is, of course, the foster mother is treated to be mother, and her daughter is treated as the sister of that man, and therefore she is prohibited for the sake of marriage. Similarly, a woman is prohibited to marry her foster son. A woman cannot marry her foster son and foster mother's son. Again, the foster mother's son will be equal to brother, and therefore she cannot marry with foster brother. So these relations are, there are many other examples, but I don't want to complicate. I have given you the simplest possible example because for many people this fosterage and relation by milk becomes difficult to understand. The prohibition on the ground of fosterage has almost become outdated nowadays, because in most of the families of Indian Muslims, this relationship is not in practice. As I already told you, that such relations existed in old days. Nowadays, such a relation is not witnessed in the society. We do not find such relations, or we rarely find such relationship. However, the possibility cannot be ruled out, and therefore when we are studying prohibitions, we must study this point also. And if in lakhs, in crores there is one situation, and the question arises whether marriage is possible or not, and if that relationship falls within the category of relation by blood or fosterage, the answer will be very clear, and you will be able to answer whether the marriage is possible or not. Now, so far we discussed absolute prohibitions for the sake of marriage. Now we are going to discuss relative prohibitions. Relative prohibitions are not mandatory. However, they too are considered necessary. They should be observed. But the violation of those prohibitions do not result in the same consequence as we witness in case of absolute prohibition. Now, I'm giving you example. A marriage contracted in violation of these prohibitions means relative prohibitions, is merely irregular. Remember, I'm using a new term. Merely irregular under Sunni law and not void. I repeat, a marriage which is contracted in violation of these prohibitions, meaning thereby relative prohibitions, is only irregular under Sunni law and not void. We have studied that if a marriage is contracted in violation of absolute prohibition, the marriage becomes void under all schools of Muslim law. Here I am saying that under Sunni law, if the marriage has been contracted in violation of relative prohibition, that marriage is not void, it is merely irregular. But there is a difference. Under Shia law, such a marriage is either valid or void. It may be valid also, it may be void also. When it is going to be valid, when it is going to be void, we will come to know later on as we proceed. Therefore, remember one more thing. The relative prohibitions are actually some small irregularities. The violation of any relative prohibition in marriage is because of some small irregularity. As soon as that irregularity is removed, the marriage becomes perfectly valid. Now, with this background, let us try to understand what are relative prohibitions. The first relative prohibition is unlawful conjunction. Unlawful conjunction. Conjunction means union. Conjunction means union of husband and wife. Pati patni ka sambandh. Unlawful, IVth. So, the first relative prohibition is known as unlawful conjunction. Unlawful conjunctions may be of two kinds because of two reasons. The first is because of the number of wives. Number of wives. Under Muslim law, a man is allowed to marry with 4 wives at a time. And this is true. Although I have not discussed this point, I'll try to discuss some other day, not in this slide, what exactly the provision of Muslim law is. Or even if I do not discuss, you can find the discussion on polygamy under Muslim law in every book. If you read the book of Khalid Rashid or R.K. Sinha, or you study the book of Aqil Ahmad, in all these books, they have explained what exactly the provision under Muslim law is. So if anybody who is interested may study from any of the books which explain as to what exactly the provision of provision with regard to polygamy under Muslim law is, whether it is mandatory or Muslim law actually restricts polygamy, what exactly the situation is. If I find time, I'll try to explain some other day, but it is not possible in the present slide. Therefore, let me move ahead. So, the first unlawful conjunction is based on the number of wives. Now, 4 marriages are valid under Muslim law. Suppose a man who already has 4 wives gets another wife, he marries with another wife, that means he marries with the 5th wife. What will happen? What will be the legality of the 5th marriage? Under Sunni law, such a marriage, the 5th marriage, is not void, it is merely irregular. However, under Shia law, such a marriage is void. Under Sunni law, where it is only irregular, the same marriage becomes valid if marriage with any of the first 4 wives gets dissolved. And marriage under Muslim law gets dissolved both by death and by divorce. If any of the first 4 marriages gets dissolved, the 5th marriage will become valid. However, Shia law is different on this point, and it says that 5th marriage is completely void. Now, under unlawful conjunction, there is one more group of unlawful conjunction, one more situation where when a case of unlawful conjunction arises. Here, if a Muslim, suppose a Muslim marries with 2 women and they are related with each other. He marries with A and then he marries with B. Both A and B are related with each other. How are they related? They are related in such a way that if they had been of different genders or sexes, they could not have intermarried with each other. Suppose A and B are sisters, and the man wants to marry or marries with A and B both. First he marries with A and then he marries with B. A is alive and he marries with B. Both A and B are sisters. If any one of them was of the opposite gender, they would have been brothers and sisters and they could not intermarry with each other. This is called, this is the situation which I am explaining. Now, under Muslim law, a Muslim is not allowed to have 2 wives at a time if these 2 wives are related to each other by blood, by marriage or fosterage, in such a manner that if they had been of different sexes, they could not have intermarried. The simplest example is of 2 sisters, A and B, which I told you. Now, suppose a man marries with A and during the lifetime of A, he marries with B also. Is it allowed? Now, listen to the answer. Muslim law, under Sunni law, says that such a marriage is unlawful conjunction. The second marriage, the first one with A is valid, but the second marriage with B is not valid, but it is irregular. However, under Shia law, such a marriage is void. There is a difference between Sunni law and Shia law on this point. Under Sunni law, such a marriage is irregular, merely irregular. Under Shia law, such a marriage is void. This irregularity may be removed if the first marriage gets dissolved. If the marriage with A gets dissolved, the marriage with B will become valid under Sunni law. However, this is not possible under Shia law. Shia law says that such a marriage is void. There are certain curious departures, certain situations which I have given in this slide, and you should read this slide. You should read this slide, and you must not go in detail at this stage. When you grow up, when you find more time, then you can study this point which I have given in this slide. Now let us try to understand the other relative prohibition. The other relative prohibition is based on religion. In my previous video, we already have discussed the religion of the parties to the marriage. And if you remember those points, then you will be able to understand this point. This relative prohibition says that a Muslim male can lawfully contract marriage with a Kitabiya female, but he is prohibited to marry a non-Kitabiya woman. I have already explained in my previous video. I am repeating the same thing. A Sunni male can lawfully contract the marriage with a Kitabiya female, but he is prohibited to marry a non-Kitabiya woman. But marriage with a non-Kitabiya is irregular under Sunni law. It is according to most of the writers. However, there are many writers who say that such a marriage is void. There is a difference of opinion on this point. But Shia law is very clear on this point. Shia law says that marriage with non-Muslim is void. Marriage with non-Muslim is void. A man cannot marry a non-Muslim woman in the nikah form. This marriage is not possible. As far as a Muslim woman is concerned, she is prohibited to marry a non-Muslim man, whether she is Sunni or Shia, doesn't matter. She is prohibited to marry under all schools. She cannot marry a non-Muslim male. Now, the next relative prohibition is marriage without witnesses. I have already told you in my previous video that Sunni law prescribes that for a valid marriage, presence of competent witnesses is necessary. Suppose there are no witnesses, or witnesses are there but they are incompetent, what will happen to that marriage? Sunni law says that marriage is irregular. How that will become regular or valid? This irregularity is temporary irregularity. The moment the marriage gets consummated, such irregular marriage becomes completely valid. Under Shia law, I have already told you in my previous lecture, presence of witnesses is not mandatory. Even without the presence of witnesses, marriage is fully valid under Shia law. Now, next relative prohibition is marriage during iddat. Marriage with a woman who is undergoing iddat. For most of you, or almost all of you, this term is a new one. Now let me tell you. Muslim law prescribes that a woman who is observing iddat should not marry during the period of iddat. But what is iddat, by the way? It is the period which a woman has to undergo after divorce or death of her husband. In case of divorce also, in case of death of her husband also, she has to observe iddat. What for she observes iddat? Let me explain. In the bottom of this slide, I have given you the explanation. Iddat is an Arabic word, and its literal meaning is counting. Counting the days of possible conception to ascertain whether a woman is pregnant or not. When a woman's marriage gets dissolved, there is a possibility that she may be pregnant at the time of the dissolution of marriage. Now, if she immediately after the dissolution of marriage gets married with another man and later on she gives birth to a child, a question will arise as to who is the father of that child. Who is the actual father of that child? And this is a legal question, because with this question there are so many other legal issues are related. Maintenance, guardianship are the example of those legal questions which arise. So a woman has to undergo, Muslim law says that if the marriage of a woman has dissolved, she should wait for some time. She should not immediately get married. And this period is not a very long period. In some situations, this period is about 4 months, 10 days. And in other situations, it is about 3 months. And if she is pregnant, it goes till delivery. She has to wait. And only after the iddat passes, she is free to marry. Because in that situation, the pregnancy will be either obvious or it will be found that she is not pregnant. In both the situations, the uncertainty regarding the paternity of the child, a possible child in her womb, will be determined. For this purpose, Muslim law prescribes a period which is known as iddat. Now, if suppose a woman is undergoing iddat, and during that iddat she gets married with a man, what will happen to that marriage? What is the legality of that marriage? Sunni law says that such a marriage is merely irregular. Shia law says no, it is void. I repeat, under Sunni law, marriage with a woman undergoing iddat is merely irregular. However, under Shia law, it is void. One more situation of relative prohibition is marriage during pilgrimage. This prohibition is found under Shia law only. Sunni law does not make any such prohibition. And there is only one pilgrimage under Muslim law, recognized under all schools, and that is known as what we call Hajj. You must have heard this term. Muslims go for Hajj. That is the only pilgrimage, Tirth Yatra, which is recognized under Muslim law. So Shia law says that marriage during pilgrimage is prohibited. And if anybody marries during pilgrimage, during Hajj, then under Shia law, such a marriage is void. This prohibition is for a certain period only, for a specified period of time only. When the person completes Hajj, after completing Hajj, he or she is free to get married. Even Shia law in that situation does not prohibit such a marriage. But during Hajj, the Hajj is going on. The pilgrimage is going on. Shia law says that no, you cannot marry. And if you marry, that marriage is void. But under Sunni law, such a marriage is perfectly valid. Even during Hajj, marriage is possible, and if anybody enters into the contract of marriage, such a marriage is perfectly valid under Sunni law. So that is all that I want to discuss today. Thank you very much. With only one caution, that whichever lecture you are listening, you must read the books also. After listening to my lecture and watching my PowerPoint presentations, you must go through the books also. Only then you will be able to comprehend this discussion completely. Thank you very much.